Good evening and welcome to The Link. We thank you very much for always joining us every week. And we sort of don't sleep actually thinking about the most relevant things we can discuss with you, information that you can use and opportunities. Tonight we're dealing with an issue we have only partly touched, and you can call it part one of the Employment Amendment Act. A couple of weeks ago we were dealing with part one, if you like, and we dealt with the issues around domestic workers and areas like sick leave. But then there are very important areas we did not discuss. That's why tonight the theme you might see on your screen there is employer-employee relations, what the law has changed. We are going to go into certain specific areas of that law so that we generally give you a full picture. You can call this part two. And tonight my guest is Counsel Crispus Mutabuza, who is a partner with KTA Advocates. Crispus, welcome.
Thank you, Sam. Thank you for having me on the show.
I already said that now you are our teacher this evening.
Pleasure to be.
All right. Let's start straight away. The employment law has changed terms and conditions around which an employer can end someone's employment, or your boss can say you go. Take us through the things that changed that we need to take note of.
All right, thank you, Sam. Believe it or not, the 2025 amendment to the Employment Act is actually one of the most positive legacies of the 11th Parliament. Because for many Ugandans, employment that affects the bottom line is one of the things that affects them more than any other thing that people engage with. So that act has had a thorough review for a period of about 10 years.
Okay.
And so the fact that it got assented to quite recently by the president was quite a very big catch, at least for the Ugandan population. So in terms of termination and dismissal, actually one of the legal tragedies of the previous act was the use somewhat interchangeably of the two terms.
Yeah, I was going to ask the difference.
Termination and dismissal, exactly. So I think for a media house like this, a report being made that so-and-so has been terminated or so-and-so has been dismissed, they carry a distinct and different connotation. And so you will see maybe later on I go in the explanation how someone might feel reputationally damaged if that report is not as accurate as it is. So we could start with termination. Termination generally deals with it connotes cessation of employment based usually on factors such as expiration of a contract.
Okay.
It's not discipline based.
No,
It's not fault based.
Yeah.
You sign up for a contract of 5 years, it comes to an end. Maybe there are redundancies. I think we shall get into that again. They come to an end.
So there's no renewal, so you are terminated.
Exactly. Sick leave, maybe, and you need that. The new act addresses. It makes a change from the 2 months previously to now 6 months.
Yes.
Okay. So termination generally has a connotation of it's not fault based, and so employment comes to an end in that regard. Dismissal, however, generally deals with fault-based issues. Discipline, basically. So you can see how when a report is made that so-and-so has been dismissed, yet it was simply a termination, someone might feel reputationally damaged. Okay, and so it's important that first of all, the public gets to understand. So actually, one of the tragedies of the previous act was that those words were interchangeably used. So it used to create, there was a ripple effect of uncertainty. Uncertainty in judicial decisions, uncertainty in interpretation of how that. But now the new amendment has that very clear. And so for termination, like as I mentioned, it's instances like expiration of a contract. You have redundancies. So redundancies themselves, again, for people to understand, it really means cessation of employment. But usually based on business decisions. Okay, so it has nothing to do, for instance, with competence. So the Act clearly delineates certain instances, such as maybe change of work patterns, That's basically a change of how work used to be done at the workplace.
Technology
that could cause
comes in.
automation, AI, we're in the era of AI, you know, technology, that kind of thing. At KTA we have remote working. It's a hybrid model.
Yeah.
So it means at any given time, half the team is physical, the other team is remote.
Off-site.
So what that means is that when we implemented that and we did a human resource review, certain jobs could have been
redundant.
If we had 6 cleaners at the time, for instance, or supporting staff, maybe now we no longer need as many. That's what redundancy means.
They become redundant.
They become redundant. But the Act now clearly delineates how that procedure is handled. Whereas in the previous Act was quite unclear. And so that created a lot of, it was really causing a lot of consternation, especially among people. I think during the COVID period, we had the highest number of instances, issues that raised regarding redundancies, because they're not quite clear. A lot of things were the instance of the employer. So right now with this new Act, the Act asks employers to factor in employees in the decision-making that arrives at a point of redundancy. So what that means is, like, for instance, if you need to take a decision to that
redundancy
effect,
here I can add, counsel. Restructuring.
Restructuring as well, exactly.
Redundancy is restructuring.
Exactly. Restructuring. Organizations and companies can restructure, they can downsize, they can, you know, I've talked of automation. So all those things, they affect, they may affect when you do a human resource audit, you may no longer need a certain number of people. Certain roles are rendered redundant by use of technology. Now we have like I say, the AI coming in. So if you had a clerk who was delivering papers, physically documents to your clients, now you have
a computer system.
A computer system that can send an email. That person is not being terminated because of a competence issue. It's just a redundancy issue.
They are not needed.
Exactly. It's unfortunate, but that's the reality. So the actually it gives employers that obligation to place employees really at the forefront in that planning. For example, the notice. The notice has to be, now it's, the Act provides for 30 days notice given to employees. And
30 days before you lay them off.
30 days before you lay them off. And that allows, and that includes having a clear written reason stating why that is being done, the criteria that was used. Remember, I talked about doing a human resource audit. You simply have to explain that maybe that role is no longer needed. And then, so also to avoid issues of bias, because maybe you could say that why me, why not Jen? All those issues tend to come out when these things are discussed. So
can I object?
Well, you can object to the redundancy if there is a grounds, credible grounds to do so. But now the employer has got to prove. For example, the Act clearly states that A may be cessation of business. You're going to close. So I don't know how you object if I've told you that we're going to shut.
I couldn't object in that case.
You understand. Or if I've told you that now there's a system that allows us to do the work faster and better, and so we may no longer need this. So you either upskill or you get an alternative employment. So that's termination per se. I think it gives a very clear.
Let's hang on redundancy. It's a very interesting issue. The money. So the law says something about the money. When they are telling me to go. Previously they could do whatever they wanted, but now what changed?
So previously there was the situation left employees at the behest of the employers, especially in regards to the computation of severance pay, which is I think again something we should get into. But so basically the new Act clearly states
they call it the package.
Or you could call it a package. So it's the formula against which this computation is done. Now it's quite statutory, it's very clear. It is a year's salary for a month's salary for each year worked. So that kind of takes away the uncertainty around the computations. It's very clear in terms of arriving at.
So let's say it's slowly, council. People write, they say a monthly salary for every year worked.
A monthly salary for every year worked.
If I've worked for 10 years, they're going to give me a 10-month package.
Exactly. So you simply get your salary that you earn every month. I'm sure you know it. Then you just compute times the number of years that you have worked. So whether it's 10, 5, 15, 20, it's very clear. So what that does is that there is clarity, both on the side of the employer, even though they may not like the higher
number.
But at least now it's very clear that they can now put it in the budgetary planning ahead of the decision of redundancy.
Very good. We are going for a short break. And we are going to come back and still talk about if anything changed with termination and dismissal. Remember, the council told us they are different. Termination and dismissal. Termination is end of contract. Dismissal is behavioral, or they are discipline issues. We hope we're adding value to you so far. We are going to add more value to you. Don't go away. We're coming back after the break. This is the link. Welcome back from that break, and we are discussing employer-employee relationships and what the law changed. And today we're discussing areas around dismissal, and I'm forgetting that word, dismissal, redundancy, and things like that. What are your rights, in fact, if you're an employee? You need to pay attention, but even employers, because when you go to court, I'm told employers rarely win because they have not done their homework with the law. So it's important that you know. And in the studio, my guest is Counsel Crispus Mutabuza, a partner with KTA Advocates. And what you see on the screen there, we're discussing that employer-employee relationship, what the law changed. So Crispus, let's move on now. Let's stick still with termination and dismissal. What changed with the law? Maybe dismissal? Whatever you want to start with.
Yeah, so with dismissal, I think we addressed termination in the segment before, but with dismissal, like I said, it's now it's discipline related. That's the distinction from termination. So the Act clearly states the parameters that govern, that warrant proceedings of dismissal proceedings, I should say. One of them is abscondment from work. What that means is basically for 30 days, if without knowledge of your employer, you disappear, you don't
appear at work.
Yeah, exactly. That's a grounds for dismissal. The other is presenting forged documents. The Act calls them misrepresentations. So what that means is basically those who put in their CVs
NASA Road
10 years experience when you graduated 4 years ago. That's a grounds for dismissal. And the other is
okay. I noticed also that with dismissal, you mentioned 30 days of abscondment. So if I abscond for 15 days, what happens?
Well, I'm sure every employment entity has got internal procedures and guidelines that govern even 1 day, even 6 hours, 3 hours. Here, the point was to show the statutory limitations. So they are beyond the provisions I've mentioned in the statute. There are those that are contained in each person's employment contract. Okay, so the statute provides for the abscondment, for the forged documents. It also provides for conduct, whether in the office or outside the office, that can that adversely affect the business of your employer. So, for instance, we know, like just maybe for example, if you are you're an employee in this entity, and then you engage in activities, maybe terrorism or what, that would now give your your employer, this business, a very bad name. That's grounds for dismissal. The last provision that is provided for in the Act is what's provided for in the
contract.
So you have your contractual obligations that you're supposed to meet. So your 15 days, right? There are certain penalties that are attached to whatever discipline-related issues you have, whether they are hearings that you'll undertake, whether there will be maybe
disciplinary committees.
Disciplinary committees. And in fact, what the new Act provides is that right now disciplinary hearings are mandatory, whilst in the previous one did not stipulate the mandatory disciplinary hearings. So now they are mandatory, and what that looks like is that you have to give the employee written reasons for why they're being dismissed in a language they understand. That should be explained too. They need to be given 5 days to prepare a defense. Okay, they can have a person of their choice, a lawyer or whoever they feel like, to be present. First of all, at the time when you're explaining the reasons, but also during the hearing themselves. Okay. So that entire procedure has got to be followed. So what the Act again clarifies is in when provisions in the previous Act were stating, were providing for unfair dismissal, unfair termination. At least now it's very clear. So, for instance, dismissal is unfair if it's not done according to the things that we've gone through.
In the law.
Yeah, in the law, the reasons that we have delineated. Okay. It's wrongful if the procedure is not followed. For example, we've said that we've talked about the example of absconding from work. So the person, we've determined that they absconded from work for 30 days, okay? But then we sent them an email, they don't know English, we put it in English. We did not give them time to prepare for the defense. We said in the next 6 hours, report, appear. There's a session. So you see, it's now wrongful because the procedure, there are contractual obligations which your employer has to fulfill, and that's why those claims also...
and I hope I'm not going into deeper into what you guys handle in court here, but let's say for abscondment, it says 30 days.
Yeah.
And my contract, can the contract say 15 days I can fire you in 15 days when the law says 30?
No. So the hierarchy of laws is that every other, you could say rule, you could call them bylaws because they're internal policies, right? All policies must be in conformity with the existing legislation in the country. So we have a hierarchy of laws, the Constitution, the Acts of Parliament, regulations, etc. Then we get into our internal policies. So our policies cannot be in contravention with the existing law. So again, those would be grounds to challenge that if the period of time of absconding is without. But it doesn't mean that the entity does not have internal remedies against absenteeism. For example, people are denied pay for those 15 days, right?
Okay, they may not fire you because the law may...
This is dismissal we're talking about. It's not disciplining your staff internally.
Okay, that makes sense. I was wondering how the contract interfaces with the law, but the law is above.
So now I hope you don't take leave for 29 days and be like, oh, at least I'm still with you. Then you're absconding for 29 and a half. And you're like, it's not technically 30.
Well, that can happen, but we'll come back on what kind of trouble you can get when you do that. Okay, let's touch a little bit on the labor export law, rather labor export processes. What did the new law amendment, so to speak, introduce when you're dealing with labor export or externalization?
Okay, Sam, you will agree with me that with labor export, it's actually been one of there's been a huge national outcry regarding the situation with people that are sent out, recruitment agencies. There was subsidiary legislation on the agencies, recruitment of workers, but there was nothing which was imprinted into the Principal Act, the Employment Act. So the new Act, the new Amendment 2025, it has an entire part, I think it's Part 9A, that entirely creates a framework within which these recruitment agents, the laborers themselves, and so one of the main, probably three main key things that come out, because there are quite many, that come out of the amendment. First is the contractual obligations. There are aspects like having next of kin, being present when those contracts are being signed. There is an obligation of the entity to be registered, incorporated here locally in Uganda, to be able to partake of that activity. The other is maybe also on the side of the employee, having those contractual protections. There is a repatriation clause. Okay, what that guarantees is that in the event, for example, that there is termination, we discussed termination,
lose the job,
you lose the job the other side. Or even in the event of death. We've had so many tragedies of people who can't just come back here because once the person passes on the other side, the next of kin can't afford because of poverty levels.
The agency is not liable.
So the new act puts the obligation on the employer or the recruitment agency, in this case, to, at their expense, repatriate that person back home. And I think that's a very big win for the population. I think that's quite a legacy that the 11th Parliament left in that regard.
Okay. Thank you so much, Council, on that. And if you want to find out more in as far as what changed in the law, first of all, the law is available online. You can read it. But if you can't read legalese, and it's not, the language is not too complicated, but if you don't want to, if you want to get it right, maybe you have doubts, talk to a lawyer. Get to your advocates. they deal with those issues. Find them or find your lawyer and talk about, let them take you through. The employees, rather the employers, you need to know the law because then you don't want to get in trouble. And of course the employers, the law does, employees, the law does really, really protect you, just if you know. Some employers are very exploitative, so you need to find out what the law does to protect you. And there are other aspects that we dealt with earlier, but we couldn't handle it today. So today was part 2 of the Employment Amendment Act. We hope we added value to you tonight. Thank you very much for joining us. This was The Link.